the other two being the legislative and the executive branches. It has long been recognized that in order to properly facilitate the judiciary's role in our society, the judicial actors who may make the branch function must feel free to exercise their discretion without the fear of civil reprisal. And this case was taken from Stump v. Sparksman, decided 1978. It says, hence, judges are absolutely immune from liability for judicial acts that are performed within their jurisdictional power, no matter how erroneous the act or how evil the motive. Johnson v. Keegan decided in 1989. And it says judges are granted this broad immunity because of the special nature of their responsibilities. And it says judicial immunity, which is firmly established at common law, protects not only the individual judges, but benefits the public, whose interest it is that the judges should be at liberty to exercise their functions with independence and without fear of consequences. And it says, in short, judicial immunity is an absolute immunity that protects judges and other judicial actors, such as clerks and bailiffs. Now, you heard what I said. It doesn't matter how erroneous their acts are. And let me go further. It says, absolute immunity is a tool designed specifically to allow judges the ability to effectively perform their job. A judge acting in his or her official judicial capacity enjoys absolute immunity from liability for judicial acts performed within the scope of their jurisdiction. Stump v. Sparksman. And it says judges enjoy absolute judicial immunity from liability for judicial acts, no matter how erroneous the act or how evil the motive, unless the act is performed in the clear absence of all jurisdiction. Now, remember when I was saying to you that this judge in Cobb County, who lacks subject matter jurisdiction, stuck his nose in my mother's estate case thanks to the Superior Court Chief Judge in Fulton County, who appointed him. He's not a probate court judge, so therefore he lacks subject matter jurisdiction. He's liable to me civilly. That's why I'm suing him right now. The first thing I'm doing is suing him for what he did in regards to having ordered my mother's estate closed, which he doesn't have a legal right to do. Once that's thrown out, I'm going to turn back around and sue him again for liability and for damages for what he did, because he lacks subject matter jurisdiction and he does not have judicial immunity. See, as long as you don't have subject matter jurisdiction, you're liable as a judge. But if they have subject matter jurisdiction, they can do whatever they want to do to you, just about in those courtrooms. And they know this too. That's why a lot of these judges get away with what they do. And let me also say to you, because I didn't hit a point on this last week, the Judicial Qualifications Commission is a waste of your time. If this judge hasn't done something as far as sex related, drug related, whatever, don't waste your time filing a complaint against these judges with the JQC, because they're not going to take action against these judges on your behalf. They're not. So don't waste your time with them. Let me read some more of this. A judge will not be deprived of immunity because the action he took was in error, was done maliciously. Did you hear what I just said? Done maliciously, or was in excess of his authority. Rather, he will be subject to liability only when he acts in the clear absence of all jurisdiction. That's the only time you can sue a judge for monetary damages, when they lack subject matter jurisdiction. Because again, when you lack subject matter jurisdiction, you might as well lack personal jurisdiction as well. The most important jurisdiction is the subject matter jurisdiction. The same that this particular judge in my mother's case did. He lacks subject matter jurisdiction. So therefore, he's financially liable to me. He doesn't have the legal authority to order my mother's case closed, open, put on vacation, none of that. Also, let me read more. In essence, as long as the judge acts within his judicial capacity, not administrative capacity, 2, within his jurisdiction, the judge is entitled to absolute judicial immunity. So how does a judge establish these elements? Now listen to this, everybody. The factors considered in determining whether a judge's act is a judicial one are: one, whether the act complained of is one normally performed by a judge; two, whether the act occurred in the courtroom or in appropriate adjunct such as the judge's chambers; three, whether the controversy centered around a case pending before the judge; and four, whether the act arose out of a visit to the judge in his judicial capacity. Let me read that again. The factors considered in determining whether a judge's act is a judicial one are: number one, whether the act complained of is one normally performed by a judge; two, whether the act occurred in the courtroom or in appropriate adjunct such as the judge's chambers; three, whether the controversy centered around a case pending before the judge; and four, whether the act arose out of a visit to the judge in his judicial capacity. See, it's interesting, isn't it? But no matter what these things say, the main question is, before this judge does anything to you, do they have subject matter jurisdiction to do so? That's the most important thing. And again, as I told you all last week, I filed a petition for the settlement of accounts in the probate court of Fulton County and paid my fees. Kenya Johnson is as corrupt as the day is long. She basically she granted my petition, and I called the probate court once a month trying to figure out when am I gonna get a court date, when am I gonna get a hearing. Didn't get into that. 7 months later, she recused herself without my knowledge, without my consent, with no hearing, no nothing. They sent my case to the chief judge of Fulton County. Next thing I know, because Angela McCullough, the judicial legal assistant, she lied talking about the court lost jurisdiction. How do you lose jurisdiction without prior notice to the litigants? It was all a setup because they know that I have these bank statements on Edward R. Downs Jr. and also called the previous corrupt probate court judge, Pinky Toomer, a liar and corrupt herself. No, see, they didn't want me in the courtroom to basically shut Edward R. Downs Jr. down and overturn what Pinky Toomer did. But it's not going to work. I filed a motion to transfer my late mother's case from Fulton County to Clayton County, and they're trying to hold that up too. But now that these lawsuits are getting filed and about to be filed in Fulton County after I'm done with Cobb County, my case is about to go forward. And I'm going to sue Fulton County for all of the corruption, for all of the 14th Amendment violations. And I'm going to read about that too to you all so you all understand about the 14th Amendment. I'm going to read another aspect when you can sue a judge. There's another aspect I think I told you all about when it came down to for a declaratory and injunctive relief. Another aspect to keep in mind that judicial immunity is not a bar to prospective injunctive relief against a judicial officer. A judicial officer, everybody, is the judge. I'm going to read it again. Another aspect to keep in mind is that judicial immunity is not a bar to prospective injunctive relief against a judicial officer acting in a judicial capacity or to attorney's fees for obtaining such relief. So let's just say, for instance, even if this judge is within their jurisdiction, you can still sue this judge for declaratory and injunctive relief to make another judge, i.e. the federal court, say what you're doing is wrong, or put an end to what you do, or make that judge do what they're supposed to do. You can do that as well. There is no judicial immunity when you're asking another court or an appellate court or a higher court to make this judge do their job or make this judge stop violating you. Judicial immunity doesn't apply. Now, as I told you all about the 14th Amendment, because again, when I sue Fulton County, that's what this is going to be about. So I'm going to read to you all some things about the 14th Amendment as well. Let me get that out for you. Okay. Here is about the 14th Amendment. In order to establish a procedural due process violation, plaintiff must demonstrate that the state deprived him or her of a constitutionally protected liberty, interest in life, liberty, or property without due process of law. There's a case that this centers around too. It's Zimmerman v. Birch, decided in 1990. The fundamental requirement of procedural due process is the opportunity to be heard at a meaningful time and in a meaningful manner. Matthews v. Eldridge, decided in 1976, quoting Armstrong v. Manzo, decided in 1965. Now, here is information about due process. The Fifth and 14th Amendments to the U.S. Constitution require that no person be deprived of life, liberty, or property without due process of law. Let me read that again. The Fifth and 14th Amendments to the U.S. Constitution require no person be deprived of life, liberty, or property without due process of law. The most fundamental requirement for procedural due process is, let's see, the opportunity to be heard. The U.S. Supreme Court has made clear that a trial-type hearing is not required in every case. A hearing will be deemed sufficient if it provides all interested persons sufficient opportunity to present their cases fairly in a meeting open to the public. Now, when we get to this particular situation, the 1983 civil action for deprivation of rights, because that would be a 14th Amendment. So it's basically a deprivation of your rights, meaning you're saying, I'm being deprived of my right to appear in court. I'm being deprived of my right to be heard. Now, here is what the 1983 Civil Action for Deprivation of Rights has to say. Every person who, under color of any any statute, ordinance, regulation, custom, or usage, or of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Two primary issues in a 1983 action are: one, whether the defendant violated the plaintiff's constitutional rights, and two, whether such violation was under color of state law. Scott v. Dixon, decided in 1983. Brown v. Miller, decided in 1980. The gravamen of Diana's complaint, because there was someone who was suing for those particular situations. And see, however, too, when you think about it, this happens every day in these courtrooms. When you don't have your right to be heard, that's for you to deal with. And these judges know this, but they feel like because they have judicial immunity, they can get away with that, as long as they have judicial immunity. But see, there's a lot of us in the Black community, we don't take these judges to task. That's the problem, and they know that. Other races of people, they do. They will sue, they will do whatever they need to do. And as I also told you all about a will and how powerful the testator's intent is, I brought some information for you all for that as well. And as a matter of fact, if you want to Google this case, it's Stewart, basically it's Stewart Executrix v. Ray, but I'm going to give you the information so you can find it. You can Google Stewart, then EXTRX V, you can do like a small V period, Ray, R-A-Y, and then put in 2011. Again, Stewart, you can put a comma, EXTRX, then V period, Ray, then put in 2011. Let me read to you all this case. I'm going to show you all just how powerful a will is, the testator's intent. In this case, everybody, an executrix thought because the will says she had discretionary authority to do what she wanted to do, this particular executrix felt like she decided she wanted to give the beneficiaries what she wanted them to have. Well, it made its way to the Supreme Court, and she lost because she didn't like the way it went in probate court. Let me read this case to you all. And this was the top judge, and the justice rather, was David Namias, who at the time was the chief judge for the Supreme Court of Georgia. Appellant Opal Ray Stewart challenges the probate court's declaratory judgment interpreting her father's will to require equal distribution of his personal property and residual estate among his 8 children. For the reasons that follow, we affirm. When they say we affirm, what they're saying is we agree with what the probate court did or what a lower court did, as opposed to we reverse what they did. Here's the information behind this case. In 1989, Willie Ray Sr. was injured in a truck accident for which a settlement was reached in 1995 that included monthly payments of $7,639.62 for 20 years. Stewart was appointed as his conservator. Ray Sr. died testate, meaning he died with a will, on December 26, 2006. His will named Stewart as executrix. In September 2007, she instructed the insurance company to deposit Ray Sr.'s annuity payments directly into her personal account to the exclusion of her 7 siblings. Let me stop right there before I finish reading. Number one, just because you are the executrix or the executor, you have no legal authority to ask an insurance company or anybody else to commingle a decedent's money into your own bank account. That is against the law. You're not supposed to do that. I'm surprised the Supreme Court didn't check her on that. You're not supposed. That's basically against the law. That's grounds to have you removed as the executor or the executive of the estate. You're not supposed to commingle funds. That's no different if you have a joint account with your mother and your father, and you all draft a power of attorney, and you become the payee for your mother or your father. You can no longer use that joint account as a joint account, because you're not in that same capacity. You are now over, it's almost like you're in a position of authority. You can't allow any of your money to be deposited into that account anymore. Otherwise, you can be held liable for every dime in that account. You are your mother or your father's payee. That's not a regular joint account. And even if you are a pay upon death account, all that changes. Once you draft the power of attorney and you are a payee for your mother or your father, you don't have the same authority over that account. You cannot put your money in that account anymore. If you don't have a bank account, you better get one. Because let's just say that your mother, your father dies. Your brothers and sisters can order an accounting on that account that you all had. And then you're going to have to determine and say to them, okay, well, this was my money, this was your mother, this was mama's money, this was daddy's money. Any money that you spent that wasn't for the benefit of that person, you're going to be liable for it. That's no longer your money. Every dime that's in that account is supposed to belong to the person that you over. Now, once that power of attorney is ended and that authority is removed, that account can go back to what it used to be. But at the same time, if a power of attorney is drafted and you are a payee of that or a conservator of your mother or father, you have no business commingling your money into that bank account with your mother or your father, because that's not a joint account anymore. Any money that's in that account is for the benefit of your mother or your father or whoever else that you may be in charge of, but it's not for you. Let me finish reading this case. In December 2007, Stewart finished the conservatorship and was released of her duties. In 2009, her sister, appellee Brenda Ray, challenged the conservatorship discharge on due process grounds. Here we go again about the due process. The sister felt like she didn't get her day in court, so she's challenging those grounds. The DeKalb County Probate Court rejected Ray's challenge, and this court affirmed that ruling. Ray v. Stewart, 2010. In February 2010, Ray filed this action in the Fulton County Probate Court, the corrupt Fulton County Probate Court. Now, everybody needs to stop right there. This is the first time Pinky Toomer did what she was supposed to do. Because at that time, she was the probate court judge. And I'm going to tell you why I feel like she did what she was supposed to do, because lawyers were involved. That's why. Had lawyers not been involved, this woman could have got away with murder in that probate court. I know that for a fact, because I know of too many people that Pinky Toomer has allowed to violate their a decedent's will, my mother's included. In February 2010, Ray filed this action in the Fulton County Probate Court, seeking a declaratory judgment interpreting items 3 and 4 of Ray Sr.'s will. Item 3 reads in relevant parts as follows. A. All of my household furniture, furnishings, paintings, objects of art, books, pictures, silverware, jewelry, clothing, and other personal effects I give, devise, and bequeath to my 8 children per stirps, to be distributed among my children as and in the manner my executor, in his or her sole discretion, determines to be fair and reasonable. In the event that any person to whom a particular item of personal property is to be left should predecease me, or does not desire to receive such item shall either become a part of my residuary estate or shall be distributed as my executrix determines, using her best judgment, which shall be binding on all of my heirs and beneficiaries. Now here's item 4 of his will. All the rest, residue, and remainder of my property I give, devise, and bequeath to my 8 children per stirps, at the discretion of my executor, to be divided among them as and in the manner in which my executor in his or her sole discretion determines to be fair and reasonable. If any of my children do not survive me, his or her share of my property shall pass to his or her lineal descendants, if any, per stirps. If a child predeceases me without leaving lineal descendants, meaning if they die leaving no children, his or her share shall pass to my surviving children. Ray also moved to temporarily suspend the annuity payments until the declaratory judgment was issued. Ray attached a February 2010 annuity payment history showing that the payments made directly to Stewart following Ray Sr.'s death amounted to, listen to this everybody, amounted to $282,665.94. And it says, and she alleged that the future annuity payments would total, get this everybody, $481,296.06. The probate court suspended the annuity payments until further order. After a non-evidentiary hearing, the court ruled in favor of Ray. Finding that Ray Sr. intended for his 8 children to share his personal property and residual estate equally under items 3 and 4 of his will. Stewart appealed. Now, everybody, I'm going to read this to you. I want you to hear just how strong a will is when I read this to you. When I talk about the intent. Now, this is the Supreme Court of Georgia. Now, if they can't change a decedent's will, neither can you. The only way you can change a decedent's will, the beneficiaries rather, is if everybody agrees. Like I told you, if a decedent says, "Well, I want my daughter to have my house," and they got 5 children. If the daughter wants everybody to own the house, and everybody agree to own the house, there's nothing that the decedent can say about that, because Georgia has a family harmony doctrine. As long as y'all not arguing with each other, fighting with each other, and not suing each other, and if that's gonna keep y'all quiet, then that's what y'all can do. The daughter can say, "I want everybody to own the house," and everybody's name can go on that deed, despite the fact that was her house that was willed to her. She has the right to put everybody's name on that deed if they want to be on it together. Otherwise, if they don't, that's her house, and ain't nothing the other children can do about it. Now listen to this. The primary objective in will interpretation is to ascertain the testator's intent. See OCGA 53-455. Let me say it again. See OCGA 53-4. That means it's OCGA 53-4-55. If you all want to Google that. And then they have a case here. Hood v. Todd. That's again Hood v. Todd, decided in 2010. To discover that intent, the court first must look to the 4 corners of the will, and where the language of the will is clear and can be given legal effect as it stands, the court will not by construction give the will a different effect. Let me read that again. To discover that intent, the court must look first to the 4 corners of the will, and where the language of a will is clear and can be given legal effect as it stands, the court will not by construction give the will a different effect. Although the parties agree that the document is unambiguous, they differ in their interpretations of items 3 and 4. Stewart argues that as executor, she was granted sole discretion to distribute Ray Sr.'s estate unequally if she so chose, and the per stirps terms only ensured that if she determined that one of Ray Sr.'s children should receive part of the estate and that child was deceased, the property would pass to that child's heirs. Ray interprets per stirps to require equal distribution among the 8 children, with the discretionary language in items 3 and 4 granting Stewart authority only as to the manner of distribution, that is, deciding which furniture, silverware, and other items to distribute to each sibling to make their overall shares equal. Then they cited the case Bennett v. Lloyd, decided in 1980, requiring this court to construe a provision in a will using per stirps language that is essentially the same as that used by Ray Sr. There, the testator left the remainder of his estate to his nieces and nephews per stirps. Because the testator did not refer to his nieces and nephews as children of his brother and sisters, which would have meant that the nieces and nephews would have stood in the place of their parent if the parent were deceased. We concluded that they were primary legatees. Legatees mean beneficiaries, basically, and were to be taken as the stirps. We held that the testator, by this language, intended to leave equal shares of his estate to each niece and nephew. Effectively, then the testator in Bennett, they talk about that Bennett case, expressed the intent that his multiple primary legatees take as individuals and not by right of representation. And we have stated that under such circumstances, the primary legatees take a per capita or equal share. Here, Ray Sr. used nearly identical language to my 8 children per stirps to identify his children as the primary legatees. As with the Bennett will, we conclude that Ray Sr.'s will indicates that the primary legatee receives an equal share of the relevant property, and that a deceased primary legatee's descendants would then represent her, taking her representative per capita share. Ray Sr.'s intent, there we go again with the intent. As I tell you all, intent is what a will is about. Ray Sr.'s intent to treat his children equally is confirmed by his repeated use of the term share in item 4, which indicates that he intended for each child to get one. Stewart's interpretation would allow her to use her unbridled discretion to give the entire estate to herself, as she had done with the annuity payments, leaving 7 of the 8 per stirps legatees with no share at all. An interpretation that gives meaning to every word or clause of a will prevails over one that renders some parts meaningless. The probate court's correct interpretation retains meaning for per stirps and share, as well as the executor's discretion, as the executor will still have and need discretion to divide the non-fungible items of personal property and the residual estate equally among the 8 children. 3. Stewart contends that the probate court erred in ruling that she acted beyond her discretion in her distribution of the assets to date. We find no error, because under the correct interpretation of items 3 and 4 of the will, Stewart did not have the discretion to distribute the bulk of the estate to herself to the exclusion of her 7 siblings. Judgment affirmed. All justices concur. Do you understand what I mean now, everybody? As I tell you all, I'm not going to ever tell you something I don't know nothing about. I'm going to tell you the truth. A will has power. Don't ever forget that. See, the only reason why Pinky Toomer, as corrupt as she is, and I said that, the only reason why Pinky Toomer did what was right by that will is because lawyers were involved on both sides. Had there been no lawyers involved, I assure you, that executrix could have taken that man for everything he had, and those 7 children would have got nothing. And I said that. And I said to Pinky Toomer's face and anybody else's face. That includes the Supreme Court of Georgia. That's how corrupt Pinky Toomer is. She's done this to too many people, and I have facts on that. She didn't read Johnny Burke Sr.'s will. She didn't, even though my friend John Blash, his mother didn't have a will. But by the same token, the administratrix of that estate, she didn't even file. She sold my friend's mother's house without even filing a petition for leave to sell, and didn't even tell these people that she sold his house, his mother's house. What did Pinky Tuma do? Oh well, she still tried to give her money. Now the administratrix of that estate is dead. Now somebody else has been appointed. Now that person becomes liable to John Blash and his mother's estate. But again, and that was just like with Michael Burke. His father had a will similar to Ray Senior's, very similar to Ray Senior's. He gave, bequeathed, and devised to 9 of his children his house and everything that was in it. What did Pinky Tuma do? She allowed the executors of the estate to sell that man's house against the law. But one thing about it, Michael Burke clouded the title on his daddy's house. That the person she sold it to can't do nothing with that house. That house sits empty today. It sits empty today because he can't sell the house to nobody else. That man who she sold that house to can't do a thing with it. And I'm going to make sure that Michael Burke, just like John Blash, get well taken care of, because again, I'm going to put lawyers on both of those cases. I am. Pinky Tuma and this new corrupt probate court judge, Kenya Johnson, will not deprive those 2 men, just like she thought she was going to deprive James Pitts of our day in court. And Fulton County is getting ready to pay dearly for it. And I'm not concerned about the media not taking the story, because I am my own media. I don't need Channel 2, 5, and 11 and 46. I'm going to get the word out. And eventually, I'm going to be in court. And Edward R. Downs Jr. is about to be disbarred, and he will be arrested in open court. And everything that man has, I'm going after it. His house, his law firm, any vehicles he has, I already have people in place just waiting on after I'm done with court. I'm going after all of his personal property, real property. Anything he try to put in somebody else's name, I'm going to go after that too. He's married, and if he put anything in his wife's name, I'm going to go after her too. I already have copies of his deeds. I have copies of all his information. So he tries to transfer anything in anybody else's name, I'm going to go after them. So that's how you do that. Pinky Tuma, just like Kenya Johnson, are 2 corrupt lawyers / judges who should never again sit on a bench. And when Kenya Johnson's term is up and she attempts to run for office, I hope you all vote her out. Vote her out. Her, Fonnie Willis, as well as Patrick Labatt, they all need to go. I said that. It doesn't matter that I don't vote. I choose not to. For what? That's my personal preference, my personal right, and I'm going to exercise that. But what I read to you all, that just goes to show you just how powerful a will is. You have to read the 4 corners of a will to ascertain a testator's intent, or a testatrix, meaning a woman's intent. And eventually, I'm going to also read to you all a case about family harmony, because I want you all to understand how that works. And the judge doesn't even need to approve it. There don't have to be no settlement agreements or nothing. As long as the beneficiaries aren't arguing and fussing and fighting with each other, the court don't need approval, because under the family doctrine harmony, under the family harmony doctrine rather, as long as you're not arguing, fussing, and fighting, and filing lawsuits and whatever, if that's going to keep you all from doing that, y'all agree to something else other than what the will says, hey, you can do that, despite what that will says. But when you all don't agree, that will controls. And if you don't want what that person left you, you're free to disinherit yourself. You can legally disinherit yourself, and it can go to somebody else. But you do not have the right to sell something that will doesn't authorize. You don't have that right. Now, once it's in your name, that's another story. But if that will says, I give, bequeath, and devise, let's just say that will says, I give, bequeath, and devise to 5 people. And one of y'all say, no, I want to sell the house. You might want to sell it, but that's what you want to do. It's not your house to sell. Your mother or your father said, I give it to you. So why would you force your other brothers and sisters to buy you out? That will didn't give no. See, that's another thing I want to tell you all. When y'all be talking about you can buy me out, that will has to give you the right to be bought out. Stop trying to change that will. Unless everybody agrees to buy you out, nobody has to buy you out of nothing. If you don't want to pay property tax, if you don't want to upkeep that house, disinherit yourself. But that will said, I give this house to you, or I give this car to you. It didn't say, okay, in the event that you don't want it, just like what Ray Sr. said in his will, when it came down to if somebody didn't want something, give it to somebody else. You heard what I said when I was reading that case. That's what Ray Sr. said, the decedent, their father. If you didn't want what I left you, give it to somebody else in the family. And you know it goes to the other beneficiaries. But you don't have the right to sell it, though. Now, if you get it, if you would go ahead and inherit it, yeah, you're free to do what you want to do with it if it's, once you got it. But at the same time, you can't just say, well, I'd rather sell it. That will have to give you the right to sell it. Even Ray Sr. said, if one of his children didn't want what he left them, it could go to the others. But he never said, if you don't want this table, this chair, this house, this whatever, you free to sell it. He didn't say that. And no judge sitting on a bench has the authority to take that man's will and give you the right to do what that man's will didn't even give you or that judge the right to do. And that's the corruption that's going on in Fulton County. And I wouldn't doubt it's going on in other probate courts in other counties in Georgia and probably other states too. I can only be concerned about Fulton County because that's who I'm entangled with right now. I know for a fact that it's going on in Fulton County. And I know of not just myself that it's happened to. Make no mistake, there is corruption in the Fulton County probate court. And I'm going to say it again. The only reason why this woman did not get away with what she did is because lawyers were involved on both sides. That's why. That's the only reason why she was not able to basically rob the decedent, Ray Sr., as well as all the 7 children, because lawyers were involved. And it speaks for itself. Pinky Toomer didn't read my mother's will. Pinky Toomer didn't read Johnny Burke Sr.'s will. And she certainly didn't give John Blash the opportunity to be heard the proper way, even though she gave him a judgment against the administratrix of the estate. And do you know what the administratrix of the estate had the nerve to say? And I have a copy of what she said. She asked for forgiveness. Is there a law that forgives me for stealing or for taking this and selling this? Excuse me? There are no laws that forgive you for theft in Georgia. I was stunned. She asked for forgiveness. Woman, you done got over $109,000 out of this woman's house, and you asking for forgiveness? Where do they do that at? That's no different in my mother's estate. You have a lawyer dealing with my cousin, who I come to find out is illiterate. You done went to the bank the day before my mother's funeral without my knowledge, removed her money with a petition to probate her will in solemn form, a petition. And then you started spending my mother's money, you and this lawyer, on the same day that I filed a letter in the probate court. And it took me 5 years to get the proof by when I got bank statements. That just goes to show you how corrupt this previous probate court judge was, as well as the new one. I filed a petition for settlement of accounts. Michael Burke did the same thing. John Blash did the same thing. And not one of us has been to court. They're trying their best to keep us out of court. But just like I said to Michael Burke, like I've said to John Blash, I already have a lawyer in place. And I'm going to make sure that Fulton County feels my wrath. I'm going to work through this lawyer to make sure that Michael Burke's father's estate, as well as John Blash's mother's estate, is taken care of. And I don't care that they know it. And I'm ready for Fonnie Willis. I'm ready for her. I'm ready for her. Yeah, I'm going to make sure a lawyer, a very good one, get John Blash's mother's house back, as well as Michael Burke's father's house back. And then, of course, I think Fulton County needs to be sued behind that for deprivation of their constitutional right under the 14th Amendment for keeping them out of court. And this stems even into DeKalb County. This man is owed money. You don't get to sell people's houses without doing what the law says you're supposed to do. A superior court judge, it doesn't matter how long ago this house was sold, a superior court judge can void the deeds on that property. Even if somebody's living in that house, a judge can void the deeds on that property because it was unlawfully sold. And you would think, like I told Michael Burke the same thing, you would think after, because he sold his father's house in 2017. Here we are in 2022. The person who she sold that house to, he tried to sell it again, and of course, he was denied because he's afraid to take Michael Burke to court to clear that, to basically clear the title. And of course, on his father's house is that will. He doesn't want to go to court because he will lose that house in court. The person who the executor of the estate sold it to. So the house is sitting empty on Cedar Avenue, 686 Cedar Avenue. It's sitting empty today. He tries to rent it out. But see, because I put all this information on the internet about 686 Cedar Avenue, ain't nobody trying to rent that house. Nobody wants to deal with that house. Ain't nobody going to give that man a dime for a house he doesn't legally own. And let me say this clearly. The name that house is in is Paradise Gold. That Paradise Gold does not own that house. Do not rent that property because he doesn't own it. Let me say that publicly. And I'll say it to who owns Paradise Gold. I'll say it to any judge in the Fulton County Courthouse, any marshal, any sheriff. I already done. Paradise Gold does not legally own that property. So if you're looking for a property to rent, do not rent that one because you're paying somebody who does not own that property. And if you Google 686 Cedar Avenue, Atlanta, Georgia, 30318, you'll see all the information I put on the internet about it. It's even on my blog. I did it. And the Fulton County District Attorney's Office is aware of it because I've given copies of this information to Sonia Allen, the Deputy District Attorney in the Fulton County DA's office, and her investigator, Baez. So, like I tell you, I don't run from nobody. I don't hide from anybody. When I tell you I've done something, I did it. Google 686 Cedar Avenue, Atlanta, Georgia, 30318. You'll probably even see videos I've done telling people do not touch that property. Letting the world know that house is unlawfully sold. No different with John Blash's mother's house. You don't get to sell a state property in Georgia without filing a petition for leave to sell. You got to serve all interested parties, something that this administratrix did not do. Let me tell you how she did what she did, everybody. The administratrix of John Blash's mother's estate, what she did was she filed a petition to become the administratrix of the estate. Once she got appointed, she went behind everybody's back and went after his mother's house and sold it without anybody's knowledge. Then she tells him after the fact what she did. And then she lied about what she sold it for. So what I did was I went to the Deeds and Records Division and I pulled up the property and I found out what she sold his mother's house for. It was $109,000 and I gave him the copy of it. And he went after her. It's interesting, isn't it? And Pinky Toomer, she didn't, well, she put a judgment against her, but she certainly didn't, still tried to make this woman, say, well, I'm going to give you money for your funeral costs and whatnot. This woman lied and said she paid $10,000 for this man's mother's funeral. John Blash's mother had insurance. Pinky Toomer didn't verify nothing. She didn't verify nothing and still felt this woman was owed $10,000, or basically $5,000. Because after she found out that John Blash was involved and knew what she really paid, which was nothing, she still gave her some money. But this woman had spent almost the majority of the money she sold his mother's house for. And Pinky Toomer did nothing to her. Not a thing. So that will be something that we will have to take care of down the road coming up. And anything that this new administratrix of her has done can be overturned, can be reversed, and can certainly be sold to make sure that he and the other two heirs of that estate are taken care of. When lawyers are not involved, and I will tell all of you, there is no law in Georgia that says you are required to have a lawyer in probate court, but whether there's a will or not. Let me say that publicly. and I'll say the Fonnie Willis face and anybody else's face in Fulton County. There is no law on the books in Georgia that says you are required to have a lawyer involved in your estate case. When there is a will involved, that will is the lawyer, the judge, and everything that's sitting around that. Even when there is no will, Georgia already has laws on the books for that, for an interstate estate, which means you died without a will. Because when there is no will, depending upon how many heirs there are, everybody can get together and nominate one person to be appointed, or maybe two people, or even everybody can be appointed to be the administrator and administrator of the estate. You can legally do that, regardless of whether there's a will or not. You can do that. But when there is a will, only one person, well, the person in that who drafted that will, the testator or the testatrix, they will determine who they want to be the person, the personal representative of the estate. But in Fulton County, it makes no difference whether you have a will or not. If the person who's been appointed wants to violate you, they will allow them to do it. And Kenya Johnson does know I'm talking about her. She knows, she's very aware because I've already been told, yeah, I am talking about her. She reads my blogs. Already been told her and Miles Braxton, the staff attorney, they look at my social media. I sure put it up there for them to read. I don't redact nothing. Anything I say over the air, I can say it right to her face, because eventually I am anyway. Because I'm going to start going back to some of these county commissioner meetings, and I'm going to put them all on notice. I'm going to talk about Rod Pitts to his face in front of everybody in the media and everybody else. I'm going to have documents with me. When I say I'm going to expose the corruption, because I've already been to county commissioners meetings before. They are very well aware of me in the Fulton County Commissioner's office. Nothing that I say over the air, I am afraid to say in anybody's face. As I told you, I met with Paul Howard in 2013 and told him directly to his face. I called Edward R. Downs Jr.'s house. He called a law firm over 100 times. I sure did, back to back. And when I say called, at 9 o'clock at night, 10 o'clock, I didn't care. Leaving messages, saying whatever I wanted to say, calling him what he is, a liar and a thief. And I'm going to play some of these recordings on air for you, everybody here coming up. You all are going to be stunned, but it's the truth. Like I told Paul Howard, when he asked me, has the police ever contacted you about this? Yeah, they did. And like I told the Clayton County Police Department, I'm going to call him anytime I get ready, whenever I want to. And if he doesn't like it, he's a lawyer, tell him to take a warrant out for me. I don't have no problem with coming out here right to you all. He never did, though. You know why he never did? Because Edward R. Downs Jr. knows just how legally educated I am, and he knows that I have the proof that he's a liar and a thief, and he does not want to go before one of those Clayton County judges, and I say, here, judge, here's why I'm doing what I'm doing. I can assure you that district attorney out there in Clayton County ain't trying to prosecute James Pitts. They'll be prosecuting Edward R. Downs Jr. That's why they don't want me in a courtroom in Fulton County, because they know that James Pitts can legally represent himself, and plus James Pitts has verifiable documentation that calls Pinky Toomer a liar and she's trash, and I can call Edward R. Downs Jr. and everybody else that works around that courthouse liars and trash. Those bank statements are powerful. And none of these so-called elected officials want to look at those bank statements and say, Mr. Pitts, you are correct. He filed a false accounting on my mother's estate. But when you compare those bank statements to false accounting, you will see that's a false document, grounds for disbarment alone. And then you bounce the check. Lawyers are not supposed to bounce checks. And then you're not supposed to be taking estate funds and putting them in an estate account. You should have put that money in an attorney trust account. He didn't do any of that. That's grounds for disbarment. But see, Kenya Johnson, the new probate court judge, she knows how legally educated that I am, and I know these things. She doesn't want me to step in that probate court and say, here's the proof. And then when I start questioning him, she's got to sit on that bench and accept what I say. She won't be able to help him. Because these bank statements call everything that her predecessor, what she did, a lie, as well as Edward R. Downs Jr. Interesting, isn't it? And of course, if anybody want to call on my show, 470-708-1833. Again, 470-708-1833. 708-1833. You're listening to bldradio.com. Again, you're listening to bldradio.com. And of course, this is James Pitts, the host of Fulton County Exposed. I'm certainly going to expose the corruption in Fulton County. Every single day, people are dying. Every day. It makes me wonder how many more people that this has happened to. And I tell all of you, you cannot tuck your tail and run when it comes to corrupt elected officials. You cannot do that. You cannot do that. Stop tucking your tail to corrupt people who call themselves law enforcement, elected officials. See, everybody. I don't care about Donald Trump. I don't care about Herschel Walker. I don't care about none of these people because I don't vote. But what I don't like is this. I don't like that bias. I don't care what Donald Trump says. I don't follow his words. I don't follow Donald Trump. I don't care what that man says. He has the First Amendment right to say whatever he wants, just like I do. I'm not going to bash that man for his First Amendment right because I wouldn't care who don't like what I say, period. Period. And I mean that. That man has a right to say whatever he wants to say. That's the same thing with Herschel Walker. That same thing with this Warnock man, whatever. I didn't even look at that debate last night. Please. That's a waste of my time. I don't care who you all vote for. None of those people are going to do a thing for you. They're not. The proof is in the pudding. It don't make no difference who you vote for. I'm still trying to understand and figure out what exactly are any of these people doing that's a benefit to any of you. Gas prices still high, and here we have a president that ain't doing no better. He giving way more money overseas than over here. And every time I look at the homeless population in downtown Atlanta, it just irks me. When I see people sleeping on the sidewalk, sleeping on buildings, basically up on the steps of buildings. And this man is sending billions overseas to a war. And the first thing people say is, we got to vote, we got to vote. Yeah, whatever. Not interested. Not interested. But I'm not going to tell any of you not to vote. That's your right. That is your right. Do what you want to do. But as far as James Pitts is concerned, I refuse. I refuse to vote. I will never, until I have a real reason to register to vote in Georgia, I refuse to ever waste my time. The governor of Georgia is trash and corrupt. Brian Kemp. I sent that man a direct letter. Matter of fact, I did the thing online where you want to get a meeting with these so-called governors. I did that. Have proof of it. Sent him a direct letter, certified mail, to the governor's office. Have I heard from Brian Kemp? Absolutely not. Tagged him on Twitter. Go to twitter.com/James is a jeweler. Again, twitter.com/James is a jeweler. Tagged him several times. Not only him, the Attorney General, Chris Carr, he's corrupt too, as far as I'm concerned. The U.S. Attorney, which is a black man. Matter of fact, I even have email correspondence with his email address attached to it. I know how to get all the email addresses. I know how to do all that. And I have verifiable documentation to show. Have I heard from any of these people? No. Documentation is online for the world to see. They do not want, see, one thing they don't want to do, they don't James Pitts because they know James Pitts knows what he's talking about. When you have a sense of the law and you know how to go in a courtroom with a strong voice and you're not meek and weak, see, I don't have to resort to violence, none of that stuff to get my point across. And see, the day is coming. Like I told my civil rights attorney, all I want is my day in court. I want, and I'm about to get it. I'm about to get it. If it takes lawsuits to do it, I should. And as far as I'm concerned, I should have sued Fulton County Probate Court years ago, but I didn't think I would have to do that. I should have sued them right after my mother died. I should have done that. I honestly should have done that. But see, I'm not going to sit back and say shoulda, woulda, coulda. It's okay because I got a lot of knowledge out of this whole scenario. And now I can teach the public. I'm going to love this whole thing. I have absolutely no regrets, even to this very day, for anything I've done. I have no regrets. My goal is to have the Supreme Court of Georgia to see what these lawyers slash judges are doing in these courthouses, and I hope they say, you know what? I think we need to pull them in. I think we need to take them off the bench. That's my goal. I intend to expose these corrupt judges like Kenya Johnson and a lot of them Superior Court judges too. I would say Jerry Baxter, he corrupt. The one that was over the APS cheating scandal, and of course, I caught him on the elevator one time in the Fulton County Courthouse. And he when he first looked at me, I'm pretty sure he knew who I was. I said, "Oh, hey, Jerry Baxter." I said, "It's funny you gave Edward R. Downs Jr. a void judgment against me that he never commenced." He looked at me like a deer caught in headlights. I said, "You got to be careful how you turn around and rule against people." He got off the elevator so fast, just looking at me. I just started laughing. Jerry Baxter, the very same judge that was over the APS cheating scandal. Now you got the nerve to tell these teachers how they should live and what they shouldn't be doing, but you are as corrupt as any of those teachers that you call yourself trying to put a judgment on and put this and make go to jail. Christopher Brasher, he's about to retire if he hasn't already. He corrupt too. Christopher Brasher, the current chief judge of Fulton County. I said it, James Pitt, and I would say it to his face. He's very aware of me. Christopher Brasher knows me very well. As I tell you all, I don't sit on this radio or at this radio station and say something I can't back up and prove. That's why I tell people, go to twitter.com/James is a jeweler. You will see the different, even from the FBI on up. You go to my educational jewelry blog at jamesisajeweler.blogspot.com. You will clearly see just how I do what I do. It's interesting, but it happens. There is corruption in these courthouses. And we're also going to be talking about conservatorship too, in these guardianships. As I told you when I let Carmela Charrington basically tell you all about that. Kenya Johnson is behind that. How do you take this woman's father from her and her brother, and yet there was a power of attorney involved? Now, instead of allowing this woman and her brother to take care of their father, you basically tell them, "Oh, no, we'll get somebody from the court to deal with." And then you go in this man's account and take his money. The Fulton County Probate Court. You mean to tell? What do you get off telling these children they can't take care of their own parents? Oh, that would have never worked with me. No, if my mother had to survive, and of course there was a power of attorney in place. My mother had one in place, and she made me financial power of attorney. Oh, first and foremost, the probate court of Fulton County would have never even heard from me. I would have had no, let me tell you this to all of you. If there is a power of attorney in place over your parents, you don't have to legally file nothing in no probate court. Let me say it again. There is no legal requirement that you file a copy of a power of attorney in a probate court in any county in Georgia at all. That goes for a durable power of attorney or a general power of attorney or a financial power of attorney. There is no legal requirement you do that at all. And I would say to any of you, the most powerful power of attorney is a durable power of attorney. If there's any power of attorney that you want to draft, make sure it is a durable power of attorney. Because in that case, even if this person goes into the hospital, whoever they nominate has the right to say what happens if that person is in the hospital. Do your legal research, people. Durable power of attorney. Google it. Learn the different powers of attorney that works for you. That's what you do. But durable power of attorney is what you need. Get that. But you don't have to go to no probate court and file nothing. If your father or your mother has already trusted you with their assets, what have you, and again, let me also say to you all, do not take those powers of attorney and start stealing from your mother, your father, whoever else, because that falls under abuse. Because if you got brothers and sisters and they start getting a little, hey, what's going on here? What happened to mama this? What happened to this? See, then you're gonna have some problems. Whatever you do with your parents' estate, their money, whatever, you better keep an accounting of everything you do. I don't care what bills you pay. I don't care whatever you do for your mother or your father, your elderly mother, father, even if they're not elderly, it don't matter. You need to keep verifiable receipts of everything you spend their money on. If you're paying their bills, keep a copy of the bills that you paid. If you're using their money, you need to prove it. And I'm going to say to you, I wouldn't even use a bank card, especially if you're dealing with them. You need to start writing checks and write checks off of their account, not yours. Write checks off of their account and keep an accounting. So if the brother or the sister say, I want to know what you did with mother's money, or if they go and file a police report on you or call the police on you and say, I think they're stealing mama's money, whatever, living off, you can say, oh, really? Oh, okay. Here's proof that that's not true. Here's bank statements that show what she had or he had. Here's all the checks that I wrote concerning the bills. That's how you deal with that. Do not commit financial elder abuse, because that's what you will be doing if you use a power of attorney for your benefit and not your parents' benefit. If you spending their money on you, paying your bills and doing all this other stuff, you might be paying some of their bills, but you're paying all your bills. You don't bought you a car, whatever. That's financial elder abuse. And you can get up to 20 years in Georgia for that. You better Google financial elder abuse, Georgia financial elder abuse law. Read it. Read it. You better understand it's nothing to play with. The laws in Georgia when it comes to elderly people are very strict. Very strict. That's no different in my mother's case. Had my mother survived, she had made me financial power of attorney. I've never been an administrator of anybody's estate. I've never been an executive of anybody's estate. I wouldn't have known about no estate account. I'd have used my mother's account. Whatever money that was in her account, I'd have paid her bills with her money off of her account. I would have wrote checks off of her account from her account. And I'd have kept copies of all those checks to the penny. So just in case one of my brothers or anybody will say, we suspect that you took your mother's money and did A, B, C, and D with it. Oh, really? Good. Come on in here. Let me show you. Let me pull out this notebook. Oh, here's the bank statements to go to match these checks too. Let me make sure you see it all. See, I don't have nothing. I wouldn't have nothing to hide. You got to realize, people, financial elder abuse is nothing to play with. And when it comes down to these guardianships and these conservatorships, like what Carmela Sherrington is currently dealing with concerning her father, and she's going to prevail too. I promise you, she's going to prevail. She's a strong woman, her and her brother. They are two strong individuals who are determined not to be taken advantage of by Kenya Johnson, the corruption of Kenya Johnson, and the people that she put in place. And see, in a case like that, like I told Carmela Sherrington, that would be the perfect judge to sue in the federal court. Even a superior court judge can stop what she's doing. You can file a lawsuit against her for a declaratory and injunctive relief lawsuit. As I already told you all when I read earlier, there is no judicial immunity for a judge when you're seeking declaratory and injunctive relief. You can ask either a superior court judge or the federal court to make this judge either do what they're supposed to do or stop what they're doing. And then you can also, if you got an attorney to do it, that judge would have to pay your attorney fees. I forgot to tell you that part too. Yeah, that judge would be liable to your attorney for attorney fees if you have to get a lawyer to do it. No judicial immunity. Stop letting these corrupt judges like Kenya Johnson, Pinky Toomer, Jerry Baxter, Christopher Brasher, and the list goes on in the Fulton County Courthouse. Don't let them violate you. As I've already read to you all earlier, as long as a judge has subject matter jurisdiction, they can violate you maliciously. And I don't feel like, In my personal opinion, I don't think that's right. You should not knowingly, maliciously do anything to somebody as a judge, as long as you have subject matter jurisdiction. Otherwise, what are you in the courthouse for? What are you in the courthouse for? It's ridiculous. I intend to take my mother's case to so many heights. I intend to educate the public. I intend to soon have forums where people can come out and publicly meet me in person. We're gonna put a spotlight on probate issues, guardianship issues, conservatorship issues, because there are a lot of people right now being violated. If you even go on TikTok, I just saw some stuff recently on TikTok where some people went to this woman's house and this elderly woman didn't even know what was going on. They're taking her out of her house. I mean, it's just ridiculous. And she knew nothing about. Not even the family knew about it. Said a doctor said that she should have there should be a guardianship. I was stunned. You don't. I mean, you don't even know these people. But see, it's about money, everybody. Let me tell you all now. It's all about money. These judges and these people they appoint, it's all about vacuuming up your parents' estates. Whatever money they got, whatever property they have, it's about that. Selling up your mother's and father's property so they can spend the money. Call it court fees and all this nonsense. They want to make sure that the children get nothing. Don't let these corrupt tyrants deprive you of what your parents had. I would sue the doctor who told them that nonsense because see that is another case of deprivation of your constitutional rights under the 14th Amendment, and that's also ex parte communication. What is a doctor doing talking to anybody about your parents and you know nothing about it? Next thing you know, here are these people at your house taking your parents from you. You the last to know about it. I would sue that doctor, that hospital that doctor worked for. I would sue the court too. I would sue I would put them all in a lawsuit. And any money that you unlawfully stole, I would certainly sue to make you return it. Do not let these people violate you. See, that's one thing Fulton County don't like about James Pitts. They saw that James Pitts wasn't going to back down even after this unlawful arrest they tried to put on me in 2017. All these bogus lies talking about I threatened to shoot Pinky Toomer. Please, nobody studying that woman. And then as soon as I got out of jail, I went right back to my mother's case. That's what they will do. See, everybody ain't the same. There are some people like me who will stand up to your corruption. They will stand up to you. And these are, quote, court officials, people that we call supposedly honorable. There's nothing honorable about a judge who wears a black robe who knowingly violates the law and getting paid county money. That goes for a police officer too. And just look at what's going on in the Fulton County Jail right now. People getting killed in the Fulton County Jail. They got all these knives. And all Patrick Labatt wants is that city jail. He wants to put some of the inmates in the city jail. That ain't going to change nothing. Patrick Labatt is an absentee sheriff. Only thing that man want to do is run behind Fonnie Willis talking about a street gang. That's all he care about. That's all he care about. That man probably don't even go to that jail. Patrick Labatt probably hardly ever goes to the Fulton County Jail. I wouldn't be surprised how often he goes there. He probably spends more time on just out in the street doing nothing, wanting everybody to see who he is, throwing his weight around, than actually doing anything. The Fulton County Jail ain't never been the way it is even before him. Even when I was in there in Fulton County in 2017 for the brief time I was there on some false, bogus charges, please, I never saw a fight. I never saw no shanks. And the inmates treated me very well. And they try to block the Fulton County, I would just say the judges, whatever, they try to keep you from calling out the jail. I was using inmate PIN numbers and JID numbers to call out the jail. And I have proof of that. Even some of the sheriffs was like, Mr. Pitts, what did you say? What did you do? We changing your information and you still can't call out in your name? I can't. Why? They were trying their best, but it's almost like put him in jail and throw away the key. We got to keep him away from his mother's case. Now it didn't work though. See, if you want to send me to jail, show up in court. Pinky Toomer didn't show up in court. The FBI didn't show up in court. The person who lied on me with Pinky Toomer didn't show up in court. None of the Fulton County sheriffs showed up in court. None of them. Not even at my bond hearing. I was ready for all of them. And like I would say to the judge in my case, I wanted to go to trial. I did not want my case dismissed. I honestly wanted to go to trial. I wanted Pinky Toomer in that courtroom. I wanted her in that courtroom so bad. I already had my questions ready for her. But she never showed up. And as I will tell you, like I told you all last week, when the judge asked the prosecutor, I thought I told you I wanted Judge Pinky Toomer in my courtroom. And when that prosecutor, that cheap suit, tight suit, got up and smirked and said, "Oh, she decided not to make an appearance, Your Honor," the judge right back in the chair, and he said, "She decided not to make an appearance." And that's when he looked at his public defender, and he said, "Public defender, what's Mr. Pitts' charges again?" Now, as I told you all last week, they didn't even ask me could I afford my own attorney, which I could have. They had already had me a public defender. That's just how I tell you, the corruption knows no bounds. But I will say, the judge gave me a $21,000 signature bond because Pinky Toomer, as corrupt as she was, see, she knew not to show up in that courtroom because she knew I had proof that she was corrupt. I was hoping, like I told my public defender every time I would meet with her, I want her in that courtroom. And then my public defender and I, we started clashing because, as I told her, I really don't need you at this point. I'm out of jail now. I can defend myself. I have enough evidence on all these tyrants. I can go to trial on my own. I really don't need you. My evidence speaks for myself. But yet, I will say again, and every time I went to court, month after month, they would go in the back and talk. My public defender, the prosecutor, would go in the back and talk. And I asked her, "What are y'all talking about?" "Oh, don't worry, Mr. Pitts. Everything is under control." But I'm sitting in a courtroom watching everybody else's case play out right in front of me. Why y'all got to go in the back and talk about my case and I can watch everybody else's case in front of me? You know why? Because then I will tell you, one time I gave my public defender a notebook with some of my evidence to let her know. I said, "Give the DA this notebook and ask him, does he really want to go to trial? Because I do." But never did happen. I truly wanted to go to trial. I didn't want my case dismissed. But they knew just how powerful I was with my evidence against Pinky Toomer and the Fulton County Probate Court. I will tell you all, if you file anything in these courts, get a second copy. Get a court stamp copy. And I'm going to also say this to you. If you file anything in a court, I don't care if it's probate court, whatever, but most importantly in probate court, because see, probate court is different than like civil court, like I would say superior court or magistrate court. But see, now since they have the e-filing, you put in your email address, you'll get it to your email. So you don't have to worry about a second copy. But in probate court, you do. Now, magistrate court, superior court, you have to do the e-filing. But in probate court, there is no e-filing. So I would strongly suggest to you, when you go to probate court with any documents that you're filing, if you don't sign, I would say sign it right there. Especially you are a pro se litigant. Pro se litigant means you represent yourself. Sign your document right there at the probate court and request a second copy, and even let them know you'll pay for a second copy of it. Or make 2 copies of what you have, sign both copies right there in front of you, and ask them to stamp, one to go to them, and then ask them to stamp the other one for your own records. You can do that too. Don't play with these corrupt tyrants in the probate court of Fulton County. Get a second copy of anything that you file. Because as I told you all last week, when my attorney, my civil rights attorney, Mario Williams, when he called down to the probate court 2 months ago and asked about my motion to transfer my late mother's case to Clayton County, the clerk told him she has no record of me filing a motion to transfer my mother's case. Really? And as he told her, "Ma'am, I have a copy of it in my hand stamped by the court." Oh, she quickly rushed him over to Angela McCullough. And everybody, Angela McCullough or Miles Braxton hasn't contacted my attorney to this very day, but that's okay because, like I said, I'll be suing you all. I'm going to be suing you all coming up. Miles Braxton, Angela McCullough in the probate court of Fulton County, and possibly Kenya Johnson too. in your in your official capacity as the probate court judge of Fulton County. The corruption knows no bounds. You knew, Kenya Johnson, that a Superior Court judge lacks subject matter jurisdiction. You, as a probate court judge, you're not a probate lawyer. And everybody, I'm going to say it again, like I said last week, a judge does not have to be a lawyer in that capacity. As long as you have a law license, you can be a judge in the Superior Court, the probate court, the magistrate court, as long as you're a lawyer. And that's sad. Kenya Johnson should have been a probate attorney. The rest of those people that was running against her, they were probate attorneys. She should have no business sitting in the probate court as a former magistrate court solicitor, a former prosecutor in the magistrate court. You know nothing technically about probate law, as far as I'm concerned. You should not be the judge of Fulton County in the probate court. And if you sitting on a bench and you knew that Christopher Brasher was going to send my late mother's case to another county, which was Cobb County, not to the probate court in Cobb County, but to a superior court. You, as the probate court judge, should have said, hold up, Christopher Brasher, though you are the superior court chief judge, that's the wrong jurisdiction to send his mother's case to. You need to send his mother's case to the probate court in Cobb County, or let me appoint a lawyer that's a probate attorney that to stand in my place and hear his case. I'm recusing myself, but let me do that. But they didn't do that. See, it was all in an attempt to kick me out of court. Now, out of all these Fulton County Superior Court judges, all of them recused themselves, everybody. Let me make that clear. And I also have an email from the Cobb County staff attorney that shows that. He said that to me in an email to me. All of the Fulton County Superior Court judges recused themselves. I'm going to tell you why they did. All you have to do is read Heath v. Sims, decided in 2006, and you'll see why. See, when you're not legally educated, these tyrants think they can get over on you. That's the problem. But they got the right one playing with James Pitts. And see what I did with this, when it first happened, I said, I'm going to play this game right along with them. I already knew a Superior Court judge lacked subject matter jurisdiction, but I wanted to play this game right along with them because I knew I was going to file lawsuits after it's over. Anything that this judge, let's just say this judge in Cobb County would have said, Mr. Pitts, I'm going to set up a hearing for you, blah, 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 blah. Come on out here. We're going to have a hearing. We're going to have court. Do you not realize every order that this judge in Cobb County would have drafted in my favor would have been void? G. Grant Brantley would have, every order from his court would have been a void judgment in my favor. Let's just say he gave me $1 million. That $1 million judgment would have been void as the day is long. It would have been nothing. It would have been worthless. Why? Because he is not a probate court judge. He is not a probate court judge. He lacks subject matter jurisdiction. And then, of course, Edward R. Downs Jr., his lawyer, could have got it all thrown out just because of that. And guess what else he could have done? He could have sued Cobb County. Edward R. Downs Jr. Here you are, judge, putting a judgment against me, and you don't even have a right to do so. You lack subject matter jurisdiction, judge, so I'm going to sue Cobb County and you for doing that. See, a bunch of nonsense. Kenya Johnson sat back knowing that this judge in Cobb County lacked subject matter jurisdiction. Excuse me. But that's what they do in Fulton County. And it's been rampant for years. My mother has been deceased over 14 years, since March 19, 2008. And when I tell people when my mother died and how long this has gone on, they're like, wow, how do you have such staying power? Where do you get your strength from? My mother. And the fact that I'm not going to allow somebody to violate her. I couldn't care less about the money she had in her account and then nothing else she had, to be honest with you. It's about her. You're not going to do to my mother what I wouldn't have done. And if somebody else were to have trusted me with their parents, there's no way I would have done that to them. That's just not something I would have done. But yet in Fulton County, that's what's going on and been going on. You have to put a handle on these corrupt tyrants. You do. You have to do it. And anybody want to call on my show, 470-708-1833. Again, 470-708-1833. It's just really interesting, people. People are dying every day. I want to make you aware that Fulton County probate court, be on a just be aware. And I don't even want to scare you into thinking, oh, it's better. Let me get a lawyer, a probate attorney, to handle my anything concerning my mother's estate. You ain't got to do that. You don't have to do that. If I were you, do what's right, get legally educated, and if they violate you, do what I'm doing. Sue them and Fulton County. Hey, take them to court. Don't be afraid to put these tyrants in a federal courtroom or any other courtroom. It's really interesting that you've gone to law school to be a lawyer slash judge. That's if that's what you want to be, a judge. Then you have lawyers. You've gone to law school, and a lot of them think they're better than you. That's one thing I find interesting too. If you ever talk, now I'm not gonna say all lawyers because my lawyer is not one of them. My civil rights attorney is not one of them. But that I have come across lawyers who think just because they have a law degree or a law license, they're better than you. Even if you discuss law with them, oh no, you can't do this. Oh no, you can't do that. But then when I turn and say, oh really, you can't do that, then I hit them with a case. I shut them up. Oh no, you read the case wrong. Prove it. Prove it. When I say prove it, they never do. Show me case law that contradicts what I've told you, counselor. They can't stand that. Like my probate attorney who taught me estate law, he said, Mr. Pitts, a lot of lawyers and judges ain't gonna like nobody like you, but stay within the law, and that's what I do. I love stumping some of these lawyers who think they're better than you because they have a law license. I love it. You cannot allow these tyrants to. I don't listen to. I have to honestly say this. I don't listen to everything attorneys tell me and call it a fact. The reason why, I guess, because I got legally educated, learning estate law from a real probate attorney. When a lawyer tells me certain things, and I feel like it's a little fishy, I just go pull case law to see if that's true. And many a times I done found out that with some of these lawyers, not my lawyer, but some of these lawyers, some of the things they've said to me is a lie, a flat out lie. And I'm telling you, it's a lie. Just like you have even some of these lawyers, they will tell you when you call their law firms, looking for their representation. See, if they done things for Fulton County, they're gonna turn around and tell you, something else. Hold on one second, everybody. Hello? Hello? Put it on loudspeaker. Hello? How you doing? Who am I speaking with? All right, how you doing? What would you like to say? Yes. Oh yeah, I'm gonna be talking about that too, certainly. What would you like to say about it? Exactly. Have you ever had any encounters with some of these corrupt people? You don't have to. Right. Exactly. Right. And see, one thing about these appeals, and I'm glad you brought that up. One thing about an appeal, everybody, it costs like $350 to file an appeal to an appellate court, and Here's another thing. If you don't believe me, I would like for everybody to go and look at it. A lot of these lawyers too. You file an appeal to the Court of Appeals or the 11th Circuit or even to the Supreme Court. A lot of these appeals get denied. There's a lot of these appeals get denied. And when your appeal is denied, most cases you have to accept what happened in the lower court, unless you're going to go over that particular court. Well, yeah, what? Mhm. I wouldn't be surprised. I could imagine. Yeah, that's a good thing. I mean, I made it, like I said, when I first started my show about 3 weeks ago, I made it my business to create this show because, again, so though it's centered around corruption in the probate court and the superior court in Fulton County, because people are dying every day, people need to be told the truth. Because I don't want people, whether you have a will or not, you need to be told the truth about what's going on in these courthouses. Period. Exactly. Exactly. What? What? Right. Exactly. Right. And I know one thing is for certain as well. This qualified immunity, that's one thing I'm seeing that they're going after right now. I've seen some different things being done about that, and I think the U.S. Supreme Court is about to do some things centered around that too. So we shall see. But however, when you have a district attorney in Fulton County who runs from these police cases, and even if she does take one, you don't really hear anything else about it, which I find strange. But she spent more time worrying about Donald Trump and rich black rappers more than anything. And I know, and something else while we're talking about these police officers and stuff like that, just like what Funny Willis just did. She's trying to delay the case with Gunna and the other rapper several months. Yeah, because see, what she's really trying to do is keep them in jail. She know that case really is worthless, but however, she's trying to keep them in jail for as long as they can. And I'm surprised that their lawyers have not have like filed an appeal to get them out of jail. I would, well, I won't call them innocent either, but but you know what? But I tell you, but I tell you this. Just like when you say that, just like you have these police officers who are trigger happy, who have taken the lives of people, and yet they get off. Now they're free to do, and they go back to work. They're free to do it again to somebody else. Will they think about it before they do it to somebody else? We only can tell, let time tell. However, it is what it is. So hmm right. hmm Right. hmm Yeah. Right. I agree. Well, definitely, I appreciate you calling in and giving your point of view. Certainly. Definitely. Thank you. All right. But again, he made a very valid point. Matter of fact, very valid point. And that's a great thing. Because of course, yes, you do have a lot of police officers who are corrupt and all of that, and it's going to be like that until laws change. But again, You have to wonder when. You have to wonder when. So, you all who vote, it's like I'm almost speechless because it's on you all. For those of you who vote, and I find it interesting. Out of all these candidates, you never hear them talk about these hot topic issues like that. That goes for Raphael Warnock. That goes for all these Stacey Abrams. You know, even on the Republican side, you don't hear none of them talk about we're going to do things to change these laws with judicial, with either with judicial immunity or qualified immunity. We're going to give the citizens more rights to do A, B, C, and D. You don't hear none of these candidates, be it Republican or Democrat, say anything about it. And even if they win and get in office, you don't hear nothing about it. You can call them and say, hey, this is going, I've been there and done that. They do nothing. You don't hear from them. Would you get my vote? Absolutely not. No, no, absolutely not. They're not worth it. But many of you, you know, you love this Raphael Warnock. Some of y'all like Herschel Walker. I don't care neither. I don't care about neither one of them. To be honest with you, neither one of them. I don't care nothing for the current president and anybody else that take his place after he out of there. I don't care. Period. When I walk down the streets of on Peachtree, or when I'm in Midtown or Buckhead at some of these upscale restaurants, and I see the homeless community outside, and all I think about is these so-called elected officials who always talking about they so great and they're going to do so much, but you ignore the homeless community. I have no respect for you. I'm not going to turn a blind eye to the homeless community. I'm not. I don't look down on them. I mean, that's no different when you look at these other different situations. You have people who are paying, just like these people standing in these apartment complexes. They're paying rent. Some of them are paying rent. But look at the conditions they're living in. Now, where are these elected officials at? All these bogus laws that they got on the books and ain't nothing helping these people. But then on the news recently, I see in Clayton County, some of these people ain't paying rent. Landlords mad, talking about they ain't getting their money. All these other, please. I mean, let's just be clear here. I feel this way. If you are a landlord, you should, if you have all these different properties, whatever, and you talking about I'm going to lose this house, what was you doing before that? It's almost like, are you just living off rent payments every month? What else do you do? You got to have more than just that. These people's rent every month. And then, of course, you're saying, well, and of course, yes, the courts are backed up right now. The courts are backed up right now. Pre-pandemic, whatever. But even if you get these people out of your house and they get evicted, and then somebody else move in, what difference is that going to make? And I don't have anything against landlords, whatever. But by the same token, some of these houses and apartments that these people are living in are horrible. The conditions are horrible. Only thing you all care about is getting rent. They call you and say, "Can you fix this? Can you fix this or fix that?" How long does it take you all to fix it? If you fix it at all. The only thing you want is that rent. And see, Georgia is basically a landlord-friendly state, and that needs to change. Because as far as I'm concerned, though I'm not a renter, the thing is, these laws need to change when it comes down to these renters. Because a lot of times, a lot of these renters don't have many options when it comes down to that. And when I've seen some of these apartment complexes on the news where these people, I'm like, wow, how do you do it? How do you do it? But hey, people want a roof over their head, and I respect that. And I understand that. Sometimes people have to do what they have to do. I understand all of that. I refuse to look down on these people. They got a roof over their head despite the conditions, but you got a roof over your head. And yet you're in an apartment complex. And these elected officials and these people who are running for office, They don't even try to tackle these situations. And where's your hip hop Atlanta mayor at? Just like a lot of these other mayors in these other counties, they don't even address it. They don't even address it either. Every now and then, if it doesn't really make the news, they basically keep quiet about it, and that's sad. That's really sad. But that's how it goes. And everybody, let me call Carmela Sherrington too before I get off the air. I'm surprised she hadn't called me, but let me call her and put her on. I'm gonna call her from my phone. Hold on one second, because before my time is up. Okay, I'm calling her now. Hey, Carmela, how are you? I'm on air. I'm doing fine. Anything you want to say today? Go ahead and say what you got to say. Yeah, you are. Right. Mhm. 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 Right. That is correct. Right. 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 And as I told everybody, that see stuff like that falls under financial elder abuse. That is a form of elder abuse. And see, Carmela, everybody's in New York. And so New York laws may be different in Georgia, but regardless, financial elder abuse is financial elder abuse no matter what state you're in. Mhm. They're strict here in Georgia too with it. But the question is, you know, who's going to bring it forward? Who's going to report it? That's the thing. And who's going to see it through? See, it's one thing to report it, but you also want to make sure you see it through. That's the biggest thing. Mhm. Exactly. Right. Mhm. Right. Right. Mhm. Exactly.
That is my biggest thing, and it was in the family members, and then also too with my case, it's I was speaking with you, and it's all the reading and like really really God is so imperative to read like you're saying in case laws, and you could do a different way reading.
Just like I was reading some stuff early when I first started my show today, I started reading about the qualified immunity, with the judicial immunity, all that kind of stuff. And I also read a case concerning the testator's intent when it was in regards to a will. I did all those things early in my show.
Yes, it's so important. Yeah. Because this has helped me like a total lifted burden off of me because like once I started talking with you, I'm like, wait a minute, that judge told me because I have a POA for New York, and that judge told me like she was like, oh, your POA is non and void, and I thought about it, I was like, how can a judge tell me that my POA is non and void?
Right, and from another state. You have no jurisdiction, right? You have no jurisdiction. There is no long-arm statute in Georgia for, as a matter of fact, no state where you can tell a person that their power of attorney is invalid, even in that state where they currently are. If that property is not located in that state where you are, and that power of attorney is not drafted, and even when you say that, you just can't tell somebody what's invalid when you haven't had a hearing. You haven't had an evidentiary hearing. You have not had any time for this person to come before you and present their own documentation, or even a person that is power of attorney is over. You just can't come out of your mouth as a judge and say that think it's okay. But as I told everybody earlier, as long as these judges are within their subject matter jurisdiction, they can do things in error and maliciously, and they have judicial immunity in that saying. You shouldn't have it. You should not have immunity, even if you have subject matter jurisdiction when you're violating the law. At the end of the day, it's about the law, not about whether or not you're immune from civil liability. It's about the law.
Yeah, and I was just like, and then I started talking to you, and I'm like, hey, you like, Camilla, look it up.
Right.
I was like, wow. And I said, well, maybe that's why they haven't been doing anything, because they're not going to tell you.
No.
They just think oh, she don't know. They're not going to tell you the truth.
Right. You as a private citizen, they feel like you as a private citizen, you don't know the law. We can just do what we want to do to you. That's what it's about.
You should be able to put this in value and the company system.
That's exactly what they've been doing.
Exactly.
And there's so many people that's been dealing with this, but I don't know why we're not speaking out.
Well, as I do this show, and as I file these lawsuits and start putting documents online for the world to read, because of course I want the world to be able to see just how these judges respond to James Pitts now that a very good civil rights attorney is involved and doing what he's doing. I want the world to see just how they responded to James Pitts' factual allegations. I want the world to read it.
And like you said, it's not it's not as hard as you think it is.
It's not.
It really isn't. Once you start sitting there and it seems overwhelming at first, but when you like anything, once you start looking at it and say, hey, I gotta just start, because it is, when I say it's so wrong, and then when you start reading the things that they've done to us in this country, it's like almost like you have to be on this campaign.
Exactly.
I was listening to stuff in North Carolina,
right?
How they divided these properties based on highways, remove black people from their heritage, it's like endless.
Right.
Endless.
Then they'll try to use this quote. I don't know what they call it in other states, but I know in Georgia they call it the eminent domain statute. They just take your property. They may or may not give you fair market value, or they feel like we need this area. We're gonna take your house anyway. Whatever.
Yeah. These are all the things that they're doing. And they've been doing it.
Yes, they've been doing it. Exactly.
They've been doing it. So it's definitely something that we have to really.
And see, because I spoke even when it came down to conservatorship and guardianship, I even hit on those issues earlier in my show. I talked about you a little bit, what you have been dealing with, whatever. Because as I said, as time goes, I'm going to be talking about all that kind of stuff. Because like I tell everybody, eventually I'm going to have lawyers on my show, and I'm going to be talking to them about these things. Because at the same time, again, a lot of these lawyers, you never know who's who. See, a lot of these lawyers have relationships with some of these corrupt tyrants as well. So you got to be very careful as to when a lawyer says things to you that you don't feel are correct or right or whatever, or just don't, or it feels like they're favoring them. Don't hire that lawyer. Don't hire that lawyer. Don't hire that lawyer.
It's true because even when I go to the Supreme Court and I sit there and I go to Derry Court and I see when they come out the court and they're like, oh, they're talking to each other. I'm like,
Ex parte communication, everybody. That's what that's called.
everybody see this.
Mm-hmm.
Sometimes I want to have it like hit the camera. I say, you see how they all sit together and hey, how's everything? They all
Right.
sit together. They come, like they said, they all come from the same cloth.
Mm-hmm. Exactly.
So you really do need a representative. And an attorney told me that too. This attorney told me, he said, they'll all tell you that they'll fight you. He said,
Mm-hmm.
to the top, because you really think that if I work in probate, and that's the judge that I constantly have to go, my specialty is probate, and that's my judge. You really think I'm going to really walk in that judge? I got to go. That's what I work with. That's my
Right.
law.
Right.
So I'm
Of
not
course.
going to really go in there and ruffle them up.
Mm-hmm.
I said, wow, you're right.
Exactly.
So,
Well, they were.
I always, on my phone, you are James the Savior. I'm telling you, you are saving a lot of lives. You saved mine, and I'm telling you, I didn't even know where to start.
I understand. That was me in 2008 till I started learning a state law from a real probate attorney. Yeah.
Oh, I didn't know where to start.
Mm-hmm.
I said, what is this? Like, is there a hidden camera? Am I being right?
Right. Mm-hmm.
Fact that you were just like, no, look at this, look at that. Like, hey, you don't have to take my word, go research.
That's what I always will tell anybody. It's one thing when I say stuff to people, but then I will also say, go Google OCGA this or that, or here's a case you need to read. Like I was giving out cases and stuff within these things I was reading. Again, it's very important, people. See, when it comes to the black community anyway, they always thrive off. I don't care. I don't care if the judge is black. They thrive off the fact that we as black people, private citizens, are not them. You're not a lawyer. I am. I'm the judge. I can do what I want to do. No, you can't do what you want to do to me. And I've already proven that time and time again. No, you can't do what you want to do to me. And you won't do what you want to do to me.
That's exactly what that law, that partition, the tenant in common,
right?
The partition law. That's exactly what it says. It says that the law is designed. The reason why they put that law in place is because they know that property, tenant in common, which is more than likely is two family members. They know that we probably didn't have a lot of money. That's why we had to come together to get the property together. And they know that there's probably one side want to get out of it. It's some type of conflict. And they know it's more than likely it's African Americans. And they spend a whole special, like people seek out people like us, trying to get our property.
Right. Of course.
Wow.
And
so then, try to get us to sell it.
Of course. Well, it's almost time for me to get off. It's 5:54.
Okay.
And
but the phone was working and everything.
Yeah.
Okay.
Yeah. But yeah, certainly. But of course, we're gonna talk later on. But I just had somebody call you and put you on today. Because I had already talked about you earlier and whatnot. So, but I wanted to put you on as well. Just like I'm gonna have other people on the show too that this corrupt probate court has violated. So definitely.
I do have a question for you, and I have a question for you. And how do you get like? I try to look up like how do you look up the attorneys like the bar association? That doesn't
let me tell. I'm glad you brought that question. Let me tell everybody. This is what you do. This is what I did in 2008 when I just had. Let me say this. It came to me as a dream. Something just said, find you a probate attorney to teach you a state law. I didn't question. I just did it. But let me tell everybody what you do when it comes to a lawyer. You get on Google and Google free consultation probate attorneys or free consultation criminal defense attorneys. Free, but make sure you start out with free consultation. That means you don't have to pay these people for. Like they may say, well, you have an hour of time or you have 30 minutes of time to tell me what you're going through. And they will talk with you. And they, if they want to represent you, they'll let you know that whatever. But always Google free consultation, whatever lawyer you're looking for. free consultation like I did. Free consultation, probate attorneys, what I did in 2008. And I came up with 20 lawyers. Now, the 20 lawyers, 19 said, no, we don't do that. But interesting enough, that last probate attorney who was in Buckhead said, was your mother's estate large or small? I said, it was very small. You got $3,500 retainer fee? I sure do. I'm in Buckhead on Lennox Road. Okay, here we go. I'll be there.
Okay. How do you look up the attorney's like report card?
Well, when it comes to that, well, see, this is the thing. You can't really look that up unless if you go to the bar, like say for instance, State Bar of Georgia's website. If they've been disciplined or something like that, then it'll let you know that. But by the same token, just Google the attorney's name. In most cases, and like even if you go on avo.com, or do this, you could put in an attorney's name or like complaint. Put in the attorney's name, complaint, or then reviews. Like attorney James Pitt, which I'm not an attorney. Let me say that, everybody. I'm using myself as an example, and I'm going to do that. Let's just say attorney James Pitt complaints or attorney James Pitt reviews. A lot of times, if somebody done had issues with that attorney, you're going to see what somebody has said about them online.
Okay.
So that's how you find out, even if you can't. Because see, these, like even the State Bar of Georgia, they in my opinion, they corrupt too. So they're gonna try to protect these lawyers as much as possible. Just put that lawyer's name on Google and put in complaints or reviews and see what shows up under that lawyer. See if somebody had a problem with it or her.
Looking into it, I mean, it's like, oh, only if they've been disbarred and it's confidentiality. I'm like, well, how do you know?
Right. Right.
And then it's like, oh, this is all state. You guys are all together.
Exactly. Well, it's 5:58, everybody, so it's almost time for me to get off air. But certainly, like I said, we'll be talking later on. But I'm glad you brought those questions up because, as I said to everybody else, that's what you do. You get on Google and put in free consultation, whatever lawyer you're looking for. And let me say this too: get about 5. Start with 5 of them. Start with 5 of those attorneys you're looking for. Call them up, pretty much, and go from there. But always make sure it's free consultation, whatever lawyer you're looking for.
Okay.
Yeah. Well, I'm gonna let you go, Carmela, and of course we'll be talking later.
Yes. Okay.
All right. Bye bye. But yes, everybody, it's almost time for me to get off air. But again, I'm on every Saturday from 4 to 6 on bodradio.com. Fulton County Exposed is the name of my show, of my podcast. Fulton County Exposed, because that's exactly what I intend to do. Is expose the corruption in the Fulton County Probate Court, the Fulton County Superior Court, and not just those two particular courts. Fulton County, period. Anything Fulton County related where there is some corruption and it needs to be discussed and exposed, I'm going to expose that. I'm going to educate you and inform you so you will know how to deal with those tyrants in Fulton County. I don't even care if it's on a city level, period. Corruption is corruption. And I'm not afraid to call names. And anything I say online, I can certainly say in their face. They already know that. I've already done that, proven that already. So I'm not worried about that part. But however, I certainly would expect to see or hear from you all next Saturday. And again, this is James Pitts, your host of Fulton County Exposed. I'm on every Saturday from 4 p.m. to 6 p.m. on bodradio.com. And if you have questions for me, and even if I'm not online, I'm not on the air, you can always contact me directly at 404-447-5459. Again, 404-447-5459. That is my direct phone number. But everybody, have a great weekend. And this ends my show for this week. Thank you very much. Everybody, have a great weekend. And this ends my show for this week. Thank you very much.